Good afternoon, everybody. I propose that we start. We're a few minutes late. So welcome to this session of the privacy platform dedicated to encryption today. And I'm going to be even more timid than usual and not say very much because I have a sore throat, I have a bad cold. I don't want to expose you to my creaking voice the whole time. And besides, we want to give the floor as much as possible to the experts. I have an excellent panel here. From my left to right, first Mrs. Kasia Szymielewicz, sorry, who is one of the founders and director of the Panoptykon Foundation, the Polish NGO well known to most of us defending human rights with a particular focus on the right to privacy. To my left, Mr. Michiel Pestman, who is a criminal defense lawyer at the firm Prakken Oliveira in Amsterdam, specialized in cases involving terrorism, security services, the law of war and extradition. To my right, Mr. Veld van Gemert, Deputy Director of Europol and Head of the Operations Department of Europol, managing a department of experts, specialists and analysts dealing with serious and organized crime, as well as terrorism and cybercrime, and those two in particular, most recently. And then to his right, Mr. Martijn Egberts, National Public Prosecutor on Cybercrime in the Netherlands. It's a very, very Dutch panel today. Sorry.
I'm happy to be here even more. Thank you for inviting
you do redress the balance a little bit. So the National Public Prosecutor on Cybercrime in the Netherlands, investigating big cybercrime cases together with the high-tech crime team of the Dutch police. And we'll be talking, or they will be talking today about the use and the usefulness or the necessity of encryption or a ban on encryption or something in between. There's been a lot of talk about that in the last year or so with some politicians or security people calling for a ban on encryption or saying, well, maybe not a full ban, but we do want to have the key. Then I hear other experts, including security people, even from the United States intelligence services, who are, whom you can hardly accuse of being loony lefties, like myself, saying that, well, such a ban on encryption or backdoors or holding the keys is actually not useful at all. So I hope that by the end of this session we'll have some answers to this question, because let's face it, encryption is a bit like the right to having a lock on your front door. And much as I like our police people, I really wouldn't like them to hold the key to my front door. I want them to knock and ask if they can please come in, unless they have a search warrant, of course. But okay, I'm not going to say much more. If it's okay with you, I'll stick to the order indicated on the program. Yes? No objections. Then Mr. Egberts is the first to have the floor.
Okay. Let me see. I don't know if the yes, the microphone's on. If I can have a little bit of more water. Thanks. Let's see if I get this started. Thanks. Yesterday, I was with the team high-tech crime of the Dutch police, a team specialized in high-tech crime and cybercrime, and I try to go there every week. To talk about the ongoing investigations because I'm the public prosecutor in many of those cases. And my first consultation was about ransomware. Tens of thousands of computers have been infected by malware, and in any case, 1,500 of those have been locked by criminals. Your wedding pictures, baby pictures, documents of your work, music collections and tax returns, everything is gone. Just pay 1 or 2 bitcoins and then the criminal will unlock your computer again. Whether he will actually do so remains the question, and still your computer is not free of malware, what many people think. Do you know how to pay bitcoins? Because this happens to ordinary people to an even larger degree, and you too may easily become infected. The second consultation was about a case in which RATs, remote access tools, were used. Yes. Through a company hacked mail server, and yes, unfortunately, that's quite easy, 10,000 mail messages are sent in one go to companies, in correct Dutch, English, or whatever language. In this case, in the mail, the question was asked why they had received an invoice from the addressed company. Surely it wasn't intended for them. In the mail, it therefore looks as if one company asked the other why it gets an invoice from sender, and the invoice is added to the appendix. How many of the administrative employees trained to be helpful will click on the appendix? I think, and I saw many, unfortunately, because with that the program is opened, enabling the criminal to almost literally watch over the shoulder of the computer user. This picture is, you can find it on YouTube. It isn't a real hack, it's a movie made by governments, but you will see a girl that's just moved to another apartment. She's using her computer everywhere, and she's filmed everywhere. Your typed in passwords, you will get them in a neatly well-organized file. Your emails, he will calmly read them with you. Your microphone or your camera, he will put them on if he wants to. He has the complete disposal of your computer. And what they often do with this is to adjust the flow of transactions that a company prepares using payment software. But also many private persons are victims. How many of your children or friends have a computer with a webcam in their bedroom? You don't see it if the camera is on. How many of your children or friends have a sticker on the camera? The third consultation related to Dutch servers that are being misused by very specialized cyber criminals. The Netherlands, unfortunately or fortunately, has a good digital infrastructure, cheap servers, and reliable internet, and therefore many criminals rent server space in the Netherlands to commit their crimes, to commit their attacks on banks, on oil companies, and attacks on governments. The Netherlands is in the top 10 of countries from which cyber attacks are being committed, and I'm not very proud on that. And are we really vulnerable for that then? Will they succeed? For banks, governments, and large companies are well protected, aren't they? No, they aren't. According to you, what would happen if the citizen did no longer trust internet banking? If he's afraid of the bank losing his savings? If he's afraid that the government cannot deal with the theft of his data? Will that produce damage? I think it will, and it's one of the least predictable issues, the confidence of someone else in your company's environment of safety. So, what does this all have to do with encryption? Well, in all of our cases, the suspects at least used VPN connections to log in to their CNC servers. They all use PGP. They all make sure that their computers are encrypted and that the virtual machine is running on it that is encrypted. Encryption. Encryption that the government will not be able to break. That means that we won't get anything out of the communication. For instance, we are wiretapping. The communication between two persons or the communication between two computers. All this important evidence is inaccessible for law enforcement. It is impossible to imagine life without digital technology within our society. Privacy aspects and legislation processes discussed in various countries are almost superseded when the debate takes place. In the Netherlands, the latest legislation in the field of cybercrime dates from 2006, a time without WhatsApp, a time without an iPhone, a time without cloud. In short, a time that children that are now between 10 and 15 can hardly imagine anymore. When I started to work in 1999, there was such a thing as WordPerfect. We were not connected with the world. At any rate, hardly through the internet, and an internet page was created line by line. And I'm not that old. Since 2011, a debate is going on in the Netherlands about a new legislative proposal. It has just been sent to Parliament. It will be debated there, I hope at least, in 2016. And after that, it still has to go through the Senate. We live in a time of responsible citizens, active Parliament members and interest groups, and I'm glad about it. They keep us alert, and they keep us from legislation based on unrealistic fear. A society in which emotions and issues of the day form the basis of legislation that will erode our freedoms and values is a terrifying idea for me as well. But digital crime is here to stay. We live in a time of increasing organized crime that's always cross-border and that more and more uses the latest technological development to cover up their activities. In my opinion, it's of major importance that when we argue about privacy on the internet, we realize that we all are already lagging light years behind the criminals in the fight against cybercrime as regards of detection and jurisdiction. And when we argue about cybersecurity versus privacy, in my opinion, one question should be at focus and should be answered first. Whose privacy should be protected? That of million of citizens or that of cybercriminals? Because this is the rate of computers of normal citizens infected in the Western countries. After that question has been answered, the question then follows under which strict conditions is a government then allowed to violate the privacy of cybercriminals, and how far should the authorities of law enforcement extend in order to keep the society safe. And you will understand that I value the privacy of millions of citizens a bit higher than the privacy aspects of hackers, of organized crime, terrorists who all communicate in encryption. Where all of us are able to access our files throughout the world, cybercriminals can do that better. And when you surf to YouTube and type in the search term red, you will get hundreds of instruction clips how you can best protect yourself and hack someone else with the remote access tool. And that is YouTube, the open internet. You can imagine that through more protected part of the internet, far more knowledge and methods and malware are being exchanged. To be clear, I'm not an opponent of encryption. I understand that companies want to safely communicate with each other. I understand that citizens as well don't want to feel them spied on. And we don't want a society in which a feeling predominates that the government knows everything about you and can follow everything about you. And I don't want to propose to weaken encryption. But on the other hand, we cannot close our eyes to the fact that we have already given over our privacy to a large extent in the hands of large internet companies. And, more important, we cannot close our eyes for the reality that cybercrime has become a daily reality that is making more and more victims and that has more and more impact to the life of normal citizens. In my opinion, entrenching ourselves in arguments and rigid opinions on encryption or privacy is a lost track. It is no option to do nothing, nor is it an option to do away with encryption and forbid it, for example, a Tor browser. Then what is an option? Well, for decades, governments have violated the privacy of suspects. This is nothing new. For years on end, suspects have been wiretapped. For years on end, suspects are being followed. And for years on end, information about citizens and suspects has been asked for. And citizens, parliaments, and governments also want this, because we want a society that is safe and in which punishable facts are being detected. Just imagine a situation in there has been a home robbery, and then the police would say, no, we won't wiretap the stolen telephone, because that would breach the privacy of the person who stole it or handled the stolen item. Or we would say, no, we won't do a house search at the person who probably stole the items, because that would violate the privacy and his right of residence. Or we would say, no, we will not collect evidence by watching a traffic camera, because it's fitted there for another purpose. And that violates the privacy of the criminal who drove away, or that of other people walking in the street. I don't think that's a good option, and I'm glad we won't do that. We want to find a balance between the right of privacy and the right to find some evidence and to convict people who commit crimes. But violations on the right of privacy must be bound to strict conditions. Which conditions those are, that's up for discussion. Those conditions should be laid down in laws so that citizens know what to expect. And it's not for nothing that Article 8 of the treaty allows exceptions on the legal fundamental right on privacy. An important reason is that you want to keep society safe and want to protect the citizens living in it from crime. Therefore, I plead to allow governments to violate, under strict conditions, the right of privacy of suspects within the digital environment in order to fight crime with that and to better protect society and the citizens living in it against crime. And that's why in the Netherlands the proposal is to access in a limited number of cases the computers or telephone of suspects of serious crime, and you hear it well, only the suspects, in order to safeguard evidence in it before everything is encrypted. Thank you for your attention. I have some pictures about what are the plans on encryption, but we'll see if that comes in the discussion.
Thank you very much. Did I just see a picture of a toaster?
Yes,
They're not encrypted, are they?
No.
New brand.
Somebody going to hack my bread? Or
No, because when we finally find someone who's committing cybercrime, at least we have a suspect, and we want to go to his house to secure evidence, this is what we see. We see a toaster and we see a suspect who's asking for a bottle of water, of a glass of water. He throws that in the toaster and we don't have any evidence left because it will short circuit and all the information is encrypted. We see suspects who do something with the power. So when police enters the premises, the power will cut off and everything is encrypted. For us, when we finally find a suspect, it isn't that easy to secure evidence. And that's why we want to find the secure evidence before it's encrypted.
Okay, thank you very much. I'm going to put a question to you, but I'm going to come back to you at the end. So I'll leave you some time to think about this, because I don't think anybody in this room would actually argue that the privacy of criminals has to be protected so that evidence cannot be gathered. I think what we are all concerned about is the privacy of all the other innocent people, because quite frankly, criminals aren't the only ones breaking the law. Governments are breaking the law as well, and certainly when they get the chance. And if I look at the trouble that the Dutch Ministry of Justice is in at the moment, I've got no reason to have blind trust in public authorities, and that is why we have laws and rules to make sure that public authorities too stay within the limit of the law. Privacy laws are also there to protect us from the government. And speaking as a politician, but you can also look at journalists or whistleblowers or NGOs or lawyers. They need to be absolutely sure that nobody is watching them, is collecting material on them, because that's the essence of our democracy. If I look at myself, this is not only about my private, my own personal privacy. This is also about my independence as a politician. If you want politicians, journalists, and lawyers and all the others to be independent, I mean, that's the backbone of democracy. They have to know that not only the government will not spy on them, but the government cannot spy on them. So that is what we have to find a solution for. Not about, protecting the privacy of criminals obviously is, nobody wants to defend that, or very few people anyway. But the question is, how are we going to protect innocent people then? Okay, next speaker on my list, Kasia.
Thank you very much.
Stick to your first name, it's easier.
I do appreciate taking chances with my surname. Although after what already Sophie in Veld said, I'm afraid I have little to add. Okay, let me maybe bring more context and more arguments to what you have already explained, because obviously I'm going to defend exactly that same argument, that the right to encrypt and the right to communicate in a private way is our right and not the privilege of so-called good citizens, but it's simply a right of everybody, even including the suspects or alleged terrorists. And it's only the matter of balancing later on, once we have a case against somebody, how we waive one right to the favor of, say, public security. But there should never be the presumption that our right, collective right, has been removed just because some people might be abusing it. But as I said, let me start with some context. I think in that debate there were two very important political moments or shifts. And first, of course, has been Snowden and his revelations. I was very hopeful that directly after Snowden revealed everything that he has revealed, we had a very good chance to argue against our governments that they are abusing mass surveillance techniques, not only because Snowden revealed that it is targeting everybody, but also because maybe primarily because he revealed that it's not working properly, that this kind of abuse of our privacy was not really bringing security. So back then we had a very strong chance of I believe, blocking some of the most worrying developments, including mass surveillance, backdoors, this kind of attacks on privacy. But unfortunately, at the beginning of previous year, we had terrorist attacks in Europe after some time of say, peace or at least silence. And it was that one instance proved to be sufficient to bring back very influential people like Mr. David Cameron and Mr. Barack Obama to this conversation that we should ban the tools of secure communication just because some of these alleged suspects or terrorists have been using them. They didn't really prove that point. There was no evidence behind this claim. I even read very interesting analysis of security community after recent terrorist attacks, proving that none of the involved actually used these kind of techniques. So we are again trying to catch a criminal with a tool that is completely not responding to the real problem. Nevertheless, back then Cameron said that we shouldn't allow any way of communicating among people that we cannot intercept in our country. And Obama said exactly the same, that once we have a trace of terrorism plot, there shouldn't be any tool blocking access of secret services. And of course, I see and appreciate the problem that once we know something wrong is going on, on and we have encrypted data, what do we do next? But this is an entirely different conversation than the conversation that has been started back then, namely to ban encryption altogether, to ban secure communication tools altogether. Why I do think this is a problem and not just a political conversation that we could ignore and move forward. That political conversation has great influence on companies, but also on law enforcement and on the courts. And we have already seen how companies that after Snowden started moving towards enabling more encryption, like Apple, even Google started saying these things, Microsoft, these companies stopped this movement under the pressure from politicians. And this is a huge problem that we as users have, because honestly, I think, in my opinion, the only way of bringing more secure communication is through the big companies. We won't move everybody out of the cloud that is managed by the biggest companies. We won't move everybody to secure tools that exist. Obviously, they exist, but they are niche, they are maybe more difficult to use. So we have to talk with the main players who are under big pressure from major political figures. So that's one problem that we have seen over last year. Another problem is the treatment of people who use secure communication by the courts. We have already seen a very worrying case in Spain against one anarchist group where the court held the mere fact that they used encrypted communication as a presumption of guilt. I mean, there was no way of proving them whatever was meant to be proven, but the mere fact that this anarchist community communicated in a secure way was held as evidence against them. And again, many intelligence agencies, including in my own country, start targeting people who use Tor or who use encrypted emails, just because they assume that if I'm using this kind of tools, I have something to hide. I'm showing you these instances from business and from law enforcement as, in my opinion, the logical consequence of this political rhetoric. If people who govern our country start at least saying that this is not okay, that people try to hide their communication, not just make it secure, that logic will transpire into business and into law enforcement, and we will have, or we already have, a major problem. What's the result of this game or this process? Namely, that people who want to secure their communication have a very strong dilemma, whether choose unencrypted communication and be a small needle in a big haystack and be hopeful that nobody will find my conversation on Skype or on Facebook chat because there is so many people using this unsecure communication tool, or choose the tools that I believe that there should be my right to use them, but at the same time understand it, I'm becoming a target. I'm becoming more visible for those who treat this as presumption of my guilt and not simply my need to communicate in a private way. So we are facing a huge problem, and it's not only NGOs like Panoptykon Foundation thinking the same way. I'm sure many of you have already read the report of David Kay, special rapporteur, who addressed the use of encryption and anonymity, and I'm going to quote his summary. So what David Kay says in my last year is that, drawing from research on international and national norms and jurisprudence and the input of states and civil society, the report concludes that encryption and anonymity enable individuals to exercise their rights to freedom of opinion and expression in the digital age, and as such deserve strong protection. The Special Rapporteur's report reiterated that any restrictions on encryption and anonymity must be strictly limited according to principles of legality, necessity, proportionality, and legitimacy in objective. Any public debate on the legitimacy of specific individualized restrictions on encryption must consider the critical role that encryption and anonymity play to protect and promote human rights. So again, we can consider, and I'm open to this discussion, targeted, individualized measures that could help law enforcement in particular cases, but there can be no legitimate political discussion about banning this kind of secure communication tools altogether, because such measure in itself can never be proportionate. Also, what I want to stress here is that would undermine our collective security. And again, it's not just my claim. It was Edward Snowden making this argument many times, but recently even General Michael Hayden agreed with Snowden by saying, again, I'm going to quote his opinion, "Banning encryption is not the solution to defending the Islamic State group or preventing so-called lone wolf attacks inside the United States. That kind of legislation advocated by top US law enforcement officials and various lawmakers would only make Americans' data less secure while doing little to stop terrorist communications." Thank you.
Thank you very much. I think we're actually not talking, because initially some people proposed, like David Cameron, a complete ban on encryption, and then quickly said, well, no, we don't actually want a complete ban. We just want, government authorities to have the key, hold all the keys just in case. And I think the question...
All the keys is exactly the same, so we can only discuss
well,
the way of getting the precise keys
well,
we need.
Yes, okay, but the question is then, because this question also needs to be answered, in those cases where the police, for example, or the judiciary, have a very legitimate case against somebody and they do need access to the evidence, then what? And will there be actually a technical solution possible? Because that might be the next thought. Okay, Mr. Pestman, you have the floor.
Thank you. I can't talk as fast as Kasia, but I'll do my best to finish in 8 minutes. And the 8 minutes allotted to me. I'm a criminal lawyer, criminal defense lawyer based in Amsterdam, and I represent clients, and our firm represents clients which are sometimes seen as a threat to national security. We defend alleged terrorists, we defend jihadi fighters who want to go to Syria, but we also represent independence movements in various countries. We represent anarchists, environmental organizations, people that care about the refugee problems in our country, but we also represent people that are active on the issue of animal rights. These are all groups, individuals that are targeted by our security service, our intelligence service, and they feature, our clients feature every year in the reports published by the Dutch intelligence services. And as a matter of fact, I do encourage the use of encrypted communications with them. I always explain them what apps to use in order to avoid the security services tapping their phone calls and their communications. And after today, I will also show them that there is a possibility to make it even more difficult, and that they have to install a toaster and a glass of water just in case they are visited or have unwanted visitors. Yeah. We filed a complaint in 2014. Our office, our firm, law firm, filed a complaint against the intelligence services because we suspected that the intelligence services were tapping our telephone conversations. Conversations I had with my clients, not only on the phone but also on the email. After a couple of months, more than half a year, in fact, we received the result of that complaint, and it did not have the desired effect, which was to stop all tapping. But the government had to admit, importantly, that they were in fact tapping our phones and listening in to our conversations. It didn't have the desired effect, did not stop the intelligence service doing from what they were doing. And as a matter of fact, they claimed, and rightly so, that they had the right to tap our conversations because the law did not say that they didn't have the right to do so. If the minister gave the intelligence service permission to do so, and if, in their view, it was necessary to protect national security. Legally, the intelligence services were right. Our law on the intelligence services, which is still in force in the Netherlands, does not contain any specific safeguards for the protection of privileged information exchanged between lawyers and their clients. The intelligence services in the Netherlands can tap or monitor everyone they want with the permission of the minister directly above them, as long as they like, and with every means to their disposal, which is in practice everything. And there is no system in the Netherlands of independent oversight. There's no independent judge overlooking the work of the intelligence service. It is not necessary to ask an independent body, a judge, for permission to do that, and there is no body in the Netherlands that can tell the intelligence services that they have to stop what they're doing, that can stop the interference with private communication or confidential information between lawyers and clients. To this rule, there's now, since the 1st of January, there's one important exception. Following the decision on our complaint, we filed we initiated a legal procedure, a civil procedure against the government and the intelligence services, and the Court of Appeal in The Hague ordered the Minister of Interior and the Ministry of Defense to introduce a mechanism of independent oversight. Unfortunately, not for everyone, but only for privileged conversation between lawyers, journalists, and the clients they represent, or the sources the journalists are using to obtain information. Now, more emergency law was introduced following this decision, which makes it more difficult at the moment to monitor our conversations, my conversations with my client, which is of course very important. I cannot stress that enough. Our professional privilege, our right to secrecy, our ability to speak in confidence, in private with our clients, is crucial. It's an obvious point I'm making, but it's crucial for the functioning of our legal system and our democratic society. We are, in a way, lawyers are, in a way, a necessary evil. We are here to make the clock of the legal clock of the judiciary tick. Only in undemocratic states, in totalitarian regimes, only those regimes do not respect the legal professional privilege. Without this privilege, legal professional privilege, there's no rule of law and no fair trial. To be absolutely clear, I think that I agree with the other speakers. Lawyers are humans, lawyers do commit crimes, and lawyers can, at least in theory, pose a threat to national security. We are not proposing a complete ban on the tapping or the monitoring of all conversation between lawyers and their clients and other parties. Exceptions to the rule are of course possible. I'm not talking about the key, but exceptions should be possible. A lawyer who is, for example, planning to commit terrorist acts, it's a theoretical example, I don't know of anyone who was or is, or planning to rob a bank, or to commit a murder, and there's an example which unfortunately is true. Such a person, such a lawyer can, of course, or should be able, or one should be able to tap or monitor those conversations. But, and that's a very important point I want to make today, it's not up to the intelligence services or to the Ministry of the Defense or the Ministry of the Interior. It's not up to politicians to determine when this can happen, when the exception applies. Only a judge, a truly independent body, only a judge should be allowed to take that decision. Only a judge can weigh all interests. Only a judge can take all interests into account, not only the interest of national security, but also the interest of the rule of law and a fair trial. I think that in the Netherlands, we have made important progress, although it's only a small step. And the protection that applies at the moment only applies to lawyers and journalists. But it should, of course, apply to everyone. Still, it is a step in the right direction. And as long as this journey is not terminated, as I said, this protection should apply to everyone. As long as this journey is not terminated, I encourage my clients to use as much encryption as possible. And the toaster.
Thank you very much, and my apologies for interrupting you with my coughing. I'm trying to address that. we will come back at the end of the panel with the question, because wiretapping of phone calls is one thing that can be done in a very targeted manner, but when we're talking about a ban in whatever form on encryption or not, then we're talking about all or nothing for the time being. So that's the difficult choice to make. Okay, the final speaker, Mr. van Gemert.
Yes, thank you. Thank you also for giving me the opportunity. And just before giving you the answer, if I will take this key of your house to keep it with me, I just want to flag some of the experience we have as Europol, as being a law enforcement agency. And also, I think I have to make clear there, in my opinion, is a difference between intelligence and law enforcement. Also in the Netherlands, there is a clear distinction between intelligence service and law enforcement. And I have history in the intelligence service, so there are some arguments that we could share. But anyway, now I think I would like to present towards you the experience we have as Europol, being the law enforcement agencies. A brief overview would be that there were a lot of challenges coming towards us because of the threats that we see, not only from organized crime, but also from terrorism as already being used. And if you look at our organized crime assessment that we publish every year, so in 2015, we signal the fact that the criminal abuse of anonymization and encryption technology to protect identities, communication, data and payment methods, so that's within criminal investigation, is widening. That's not a surprise, to be honest. But if you look back in 2015, in more than 75% of the cybercrime investigations that we have been supporting, the encryption was involved in one way or the other. And to give you a more concrete example, in a recent high-profile joint cybercrime operation called Jet Mozart, in which we were trying to find the perpetrators of financial fraud on banks, on citizens, most of the messages, 60% of the messages that were exchanged by the members of the criminal group were encrypted. So not all of them, but at least the conclusion was that it gave us limited visibility on what information the suspects were sharing, and in that way also not access to relevant evidence to bring towards a judge and to a court. And this means that in the cybercrime field, I think traditional police tools, even if they are targeted for the lawful monitoring of communication, but also of the activities of suspected criminals, are becoming more and more ineffective. And the same applies where it goes for, as already explained, I think, by my colleague, for the evidence on service, on hard drives, on mobile phones. If the data is encrypted, we have very limited means to investigate and to prosecute also. And so there could also be a risk on the future that this kind of cases are more or less, don't have a big chance of getting solved. So there would be also the risk in putting them aside and taking up more cases that promise to have better results. And that's not something I think the police want, and it's not something the society wants. Touching a little bit related towards this is the use of virtual currency, Bitcoin. It's been establishing itself as the single common, most used cryptocurrency for cyber criminals within the European Union, at least. And it's not longer restricted to the darknet, but also increasingly adopted in much other types of cybercrime, such as ransomware, as we've been seeing. And this also, the old issue was always follow the money. It becomes more difficult to follow the money if it's not within a system that's also controlled, like we have our normal financial systems, in which there is a balance between privacy, but also the way that a government can get information out of this system. So the increasing abuse of encryption in different fields, also in those fields that are most vulnerable for, at least also the most vulnerable victims that we have on child sexual abuse, it's increasing more and more, and in that way also becoming a big risk. And it's not highly sophisticated encryption also, but also simple ways of communication are not longer available, even if it's target investigation by the police. Tor was already mentioned, but the use of those kinds of methods make it harder to monitor criminals and other suspects and to improve the understanding of these threats. And to give you just one example from, well, already a case that has been there for a long time, Silk Road. If you look at that part in which also encryption was used for a certain part, more than 19,000 products were on this dark web available. 70% of this was related to drugs. More than 900,000 user accounts. So it was not something that was only be used by 1 or 2 persons, 900,000 user accounts, bringing up more than 1.2 billion of profit, at least, or at commercial X-trade. And also giving a provision to those who were responsible for something like 85 million euros or dollars. So it's not about just an individual case. It's also not about a thing that's not really out there. It's out there in the open and it's becoming bigger and bigger. Now to the question about what the position of, let's say, Europol, also as a response, somebody who is more or less within the European law enforcement field, if we are now in favor or against backdoors or banning encryption. I have to be clear to you, Europol has never been asking for backdoors or for banning encryption. That's not the way to deal with this issue, to be honest. So for the discussion, probably it's not so good, but in any way, we think, on the other end, that there should be also a solution to find this balance again, because the balance is not there anymore, as I tried to explain to you. And there is a difference, as I already said, between what probably the opinion is of law enforcement within the European Union and intelligence service that can have a different view. But our concern is that we are also, in protecting citizens, responsible for ensuring that the internet or the cyber world is not abused by criminals, by terrorists, or any other criminal behavior. And there is, at this moment, a capability gap between, well, the tasks that we have and the possibilities that we have to make sure that we also bring those criminals towards a judge. So what would be the solution? What are we asking for? So not for a total banning of encryption. Actually, in contrary, I think, we're also making clear to private firms that they should encrypt their intellectual property and the data of their customers. But there should be a balance by giving adequate powers also to law enforcement to commit their activities. To make sure that within the European Union there is an harmonization of the criminal policy and investigative methods that we can use. And also making clear that new techniques ask also for new solutions in this field. So there are a number of alternative measures that within the European Union even, but also in the different member states, could be taken up to balance this right and mitigate the challenges of encryption against the undermining effect of technology. So first of all, there would be the possibility to harmonize legislation on compulsory disclosure. So the obligation for criminals, if they are part of an investigative activity, to disclose this information. And if not, there is a sentence against it in relation towards the crime that they are suspected of. And that's nothing new, to be honest. We have this also if you, go out this evening, have a drink too much, and you are pulled aside, and you have to prove that you are sober behind the wheel. So, and you can choose. You can do this, and you can leave it, but then there will be also incentives for you. So it's not something new. As it goes for investigative techniques, if we cannot, be in the position to change the encryption, probably there should be the possibility for police with a thorough oversight, with a judicial clearance from a judge, to have the possibility to make sure that you get the communication before it's in the system or before it's locked into a cloud in which it's not available anymore. And when it comes to virtual currency, because I touched up on this topic also, I think the same applies for, if we have money laundering, anti-money laundering regulation in our normal system, we should also have it within the cyber part of this. And also things like know your customer, but also due diligence activities should be part of a system. And I think there are ways to create this. And then finally, I think also by improving the cooperation and coordination, but also stepping up together with academia and private industry to improve our forensic techniques, so to make it possible to have this information at the right moment also available for investigators. That's more or less, I think, what I'm in favor of. Just to conclude, I think we have to find the balance once again, because as it was been said before, our rules are not living up to the standards of our society at this moment. And there should be a balance between fundamental rights, but also the task of the police or the law enforcement to investigate criminal abuse. And in those cases, there should be the right instrumentarium available to do this. And then finally, I think we, as I mentioned also, pragmatic regulation for other aspects of the criminal activity on in the cyber world, as it goes for virtual currency, should be part of our possibilities to act on. So what I'm calling for is to invest in this balance, not for mass surveillance, but for targeted surveillance with oversight, but with the right possibility to do this. And as it goes for the key, I think, you are better off to keep the key. Blind trust is not really something that we should have, at least also a law enforcement agency and an officer doesn't have this. But anyway, if there is a need to enter, there should be also the possibility to do this. Thank you.
Thank you. I think that we could all agree on that. I'm going to come back to the questions I put to the far end of the table at the right and the left, Mr. Egberts. So, in your view, how do we make sure that we don't overshoot the goal and make sure that innocent citizens know for sure that they cannot be spied upon?
Okay. Well, the question you asked me is, how will we protect the innocent? We won't protect the innocent telling law enforcement isn't allowed to investigate the crimes that are already committed. And the same question keeps popping up, but at least in the Netherlands, there's a big difference between law enforcement agencies and a secret service. And every time they tell me, in the past, the NSA or some other secret service has violated the privacy of much too many people. I agree. I think that happened, and it's good that it's in the open. But is that really an argument to tell to law enforcement, which is investigating cybercrimes on citizens, that they cannot violate the privacy of a targeted person?
But but nobody's saying that. I made that very clear at the start. The point is, if the price to pay for that ability is that everybody could potentially be the target of spying for whatever reason, is that a price that you are willing to pay until there is maybe a different technical solution? Because it's not good enough to say, oh, well, but, governments, they behave well, they're nice people, they only do this for your own good. That all depends. Let's say that you are a Polish citizen or a Polish NGO under the new government. Can you be absolutely sure? I mean, do you just want to trust them on their blue eyes or their Scout's honor? Or do you want there to be actual protection and to have certainty that the government cannot spy on you? So my question was, because I fully agree with you on the necessity for law enforcement and even intelligence to be able to investigate, gather evidence, and all of that. That we agree on. But how do you achieve that without actually violating the rights of completely innocent citizens, people who are not under investigation, not a suspect, not charged with any crime?
By not gathering information about those innocent people. Like I said before, I'm not on a ban of encryption. I don't want to weaken encryption. I think it's a very good thing that we use encryption. Like Will said, we expect from big companies and we expect from governments to encrypt our data, their communication, but also their stored data. And if you didn't encrypt the data you stored as a big company and you have a data breach, you can get a fine. But it's quite strange that a big company can get a fine, then comes to law enforcement to say, well, please investigate because I'm hacked, and we'll have to say, no, we haven't got the tools to investigate. Encryption is here to stay, and the ban on encryption is unrealistic. But you have to find some measures to get into the communication of targeted persons. And there are technical solutions to do that. It is possible to target the person and to try to get the communication before it's encrypted. I don't want to get the data of all the other persons. I only want to get the data of the targeted person. At this moment in the Netherlands, we are, in my feeling and my personal opinion, somewhat afraid to discuss the measures, because every time the discussion will end, but government is violating the privacy of everybody. That isn't law enforcement. And if we want the protection of law enforcement within our society, we have to realize that law enforcement needs some more tools to investigate cybercrime.
Okay, but I heard you say clearly no ban, no sort of general. Well, that's good to know, because I wouldn't be surprised if sooner or later there will be a proposal on the table coming either from the Council or the European Commission for a ban on encryption. I mean, I've got no crystal ball, but I wouldn't be surprised. So that it's good to know that, you know, at least in the Netherlands, this is something which doesn't get broad support. Okay, now my question to you is the opposite. So, because I fully agree with you on all the principles, but there are indeed the practical hurdles for law enforcement. And although the argument for a ban on encryption is often linked to terrorism, if I listen carefully, encryption is actually, or anonymization, as you said, is more often used by a completely different brand of criminals. When you're talking about drugs and...
I didn't want to mention terrorism, because every time this topic is being brought up, everybody is saying terrorism or child pornography. The problem is much broader than only that. That's why I limited my presentation to the other forms of cybercrime.
Okay. In any case, whatever form of crime. So what about the plea of the law enforcement forces that they need the tools to investigate, to gather evidence?
Yes, I think we all agree on principles. From what I have heard, it's not difficult to agree on them by saying we don't want to target everybody. Targeting everybody is not only illegitimate, it's even ineffective or even stupid. We want to be able to target those who are suspects or already criminals, including by listening to their encrypted or reading their encrypted conversations. So in principle, it sounds nice, but in practice, I really don't see a method of getting there. So even from our conversation, we already have the problem of protecting lawyers and other specific, people who have the right to specifically protected communication. I cannot see any way of protecting lawyers without flagging their communication or creating something like a list of numbers or emails that could not be intercepted in that manner that we are discussing. So it's already going against really the principle of secure or secure professional communication. So in essence, I see the problem as 0-1 situation. Either I have the key that only I can wave, or I don't have that key because somebody else is having it and is able to cooperate with law enforcement. So in essence, it really is 0-1, and that's why I'm referring back to the ban on encryption, not to say that I'm advocating this, of course not, but to uncover that this is the essence of the conversation. I cannot think how we can have the encryption and don't have the encryption in some situations. So my argument here would be that we have to leave encryption as something that is untagged, because we understand that the social value of that protection is much higher than the potential gain we will have out out of banning it or undermining it, while at the same time working more efficiently with other methods of investigating crimes. Let's take metadata. We all know from Snowden and everything that came after Snowden in the debate how extremely efficient metadata can be in analyzing the networks, how people communicate, who communicates, who buys what, who sells. We don't need to know what was in the message to understand the message was about some illegal trafficking in drugs, people, or whatever comes. So my argument would be, let's help law enforcement use these methods that they already have in a more efficient, also legally protected manner with the safeguards for innocent people without undermining those areas where we cannot really win more, and it's really 0-1 game.
Yeah, thank you. I can sense that Mr. Van Gemert is very, very anxious to answer. Just one second, because I'll also come back to Mr. Pestman before we go to the audience. But there's, as you say, it's all or nothing at all. And the question is, do we rely entirely on legal protection? In other words, the government doesn't have the right to invade the privacy. Do we think that that is adequate as a protection? I'm a bit skeptical about it won't surprise you. Or do we feel that, for example, there could be different methods of law enforcement investigation, or will there be technical solutions? So I'm first going to give the floor to Mr. Van Gemert and then to Mr. Pestman, and then we'll open the floor.
Yes. Just to react, and also for the sake of discussion, I think we have to be realistic. It's all of nothing as it goes for encryption, and you know my point of view. But I think Mr. Pestman would love to have a case coming from a law enforcement saying that we have seen that there was some contact not having the content, and then saying that this was a drugs case. That will never stand in any court anymore. So it can help, but that's not enough. And the plea that I'm doing is, let's be realistic. This is a different world. Encryption should not be abandoned, but on the same time make it possible to prevent that situation that was mentioned before, in getting this information before it's encrypted. And it can be done in different ways. It could be by using the traditional techniques of sources, but also technical ways in keyloggers, in also being able to wiretap, but not, well, the phone, but the place in which things are happening. And what I see that within the European Union, even, we don't have the same way of acting. And an investigation that starts in the Netherlands will never end in the Netherlands, will directly go throughout the total of Europe and even on a global scale. So we have to step up also in the field to make it possible. And as it goes for encryption, that's true. It's zero of nothing, but not as it goes for all the other activities we should do.
Sure, that's exactly what I was suggesting. Let's use other methods that don't undermine this particular protection.
Okay. Mr. Pestman.
Yeah. That's the problem when you invite Dutch prosecutors. They're also reasonable. But if I can react to a different point made earlier, it's not necessarily about protecting the innocent only. It's also about protecting the guilty. Even guilty people have the right to privacy. For example, they have the right to communicate with their lawyer without the government listening in. The question is, when is the government, and under which conditions is the government allowed to do that? I'm not, I don't know enough about encryption to know whether it is at all possible to have a key. I understand, and it's quite comforting to hear that it is actually not possible or not easy to get this key. So yeah, that's all I want to say now. I would like to stress that it's not that easy to divide the world into guilty and innocent. And it's really important that we don't trust the government, but it should be an independent organ that decides whether we can apply measures that violate the privacy, whether before or after encryption.
Okay, I'm going to open the floor to questions and debate. Just raise your hand if you have a point. Please state your name and the person you're addressing your question to, and I would like to ask everybody to be brief, so no long political speeches, that's my prerogative. Just short, 1 minute maximum. I don't think there's a roving microphone, so you'll have to come up to the microphone here, I believe.
Okay, Tobias Morsches from Datenschutzraum, Germany. First, short, I agree with you about the topic that balance has to be established again, but I see it a little bit the other way than you. The 30 years we have massive problems with our privacy, and there has to be something done that more privacy is there. But my actual argument was another one, and you all talk about we need to look at the suspect's communication, and we cannot get our cases done when we do not have this information. And I say, if I sit in the car with my girlfriend and I talk with her, you cannot get this conversation afterwards. You can, if you have a suspect, you can bug the car and then you can listen in live when I talk to her, but you cannot 3 months later decide, oh, I want to decrypt the conversation that took place then. Why is electronic communication so different that you must have past data when you cannot have it on real communication in the real world, or would you do it on real communication if it was as cheap as digital communication?
Okay, thank you. The lady over there, could you please come up to the mic?
Thank you, Carly Neist. I just had a quick kind of statement to make, which is it's my sense of the encryption debate that often the different types of encryption and the different manners for overcoming the encryption problem get conflated. So at one end of the table, we have discussions around the problems with device encryption, preventing law enforcement activities, which can be overcome, as you pointed out, although perhaps more diplomatically than I will, through techniques such as hacking, for example. And then on the other end of the table, I think what Kasia was mostly addressing was end-to-end encryption and messaging apps which are encrypted end-to-end. And that is much harder to overcome possibly with other techniques. And what end-to-end encryption frustrates is mass passive surveillance, mostly done by intelligence services. So it's not as much of a concern for law enforcement. So I just think it's important that I think the encryption debate has come a long way, and we're not really talking about general bans on all forms of encryption anymore. I think that's a complete fallacy that nobody would agree would work in any circumstance. But I think it's really important from a policy perspective that we try to understand what exactly is the problem caused to law enforcement and intelligence, and what are the other alternatives, and what is it important to preserve, and what can't be changed, and including by creating backdoors. So I just, for the sake of having a question, I would end with saying, to Mr. Egberts, is it hacking or computer network exploitation type activities that you're referring to as alternatives, and do you think that the fact that law enforcement doesn't have those capabilities is one of the primary problems here?
Okay, thank you. I'm going to take I have 5 questions now. We're going to take it in rounds, but we have 15 minutes left, so I'm going to really ask everybody to be brief. There was one gentleman all the way in the back. No, somebody even further in the back. And then I'll come back to the others in the second round.
Just an announcement that Dread Pirate Roberts has been caught, the founder of Silk Road. In that sense that I think it is important that we separate a few discussions, because otherwise we mix everything up. I'm Patrick Pennings from the Council of Europe, and I'm in charge of the Information Society Department, which covers data protection but also cybercrime. And it's an interesting mixture in many cases. I think the persons that are involved within my department on cybercrime related issues would not have anything to do with surveillance related issues. And they take as a very strong starting point surveillance issues and criminal investigations, which are authorized by the legal system, are completely different matters. And I think that's an important issue to start with. The image of using a key for the encryption is completely outdated. It's not how it functions. Encryption is there, as all the interlocutors said, is there to stay. It is not one tool, it is not one key. It is a multitude of systems which protect both banking systems, protect civil rights activists, protect a number of interlocutors, but also can protect criminals. That is quite clear. But no system is safe. And I think it's also important that the discussion is not so much about yes or no on encryption. Encryption is there. It will remain. It's not my toaster that is going to make the difference in the end. It is going to be the fact that our human rights activists today are more and more inclined to say we have to build in safeguards for human rights activists to be able to debate freely, and in order to do so, will promote encryption. Reference has been made to David Kay. The Human Rights Commissioner of the Council of Europe has done exactly the same thing, that is to go towards the promotion of encryption, but please make the distinction on the one side between criminal investigation and the role of law enforcement, and I really don't think it is a good idea to combine law enforcement with the government. Law enforcement is not the government. And on the other side, the whole issue of surveillance issues.
Okay, thank you. Before we come to answering, I'm going to say thank you very much to Kasia, because I know you have to leave a little bit earlier, so thank you for being here with us. I think there were a few questions addressed to you directly. You can answer all three. Mr. Egberts, do you want to start?
Sure. The question to me was, do we miss hacking? Yes, we do. And we can call it, and what's in the name? Some professor called it lawful intrusion, but we know it's hacking. And do we miss that as law enforcement? Yes, we do. And why do we miss it? Not because we want to decrypt the encrypted communication, and you have a lot of tools, but we don't want to decrypt the communication that's already encrypted, but we want to get in front of that. And if you get in a computer of a suspect, then you can look up the password. Then you can look up where the computer is at, where it's located. So then you can go to the premises, do a house search, take the computer with you, and you have the password. Then you can secure evidence. It's not our intention to decrypt all encrypted communication. I don't know if that's an answer to your question.
Okay, Mr. van Gemert.
As an answer to the question about, well, why are you asking for information that's in the past? Well, to be honest, law enforcement and doing investigation sometimes is about crimes that are going to be committed, and in that way you are able to, well, and also there's a need to see what's being discussed at that moment. But most crimes are committed, and we have to go back in time to see who was responsible for this. So it's not a strange thing to use information that's from the past, be it from a video surveillance or be it from other activities like phone calls. So retention, and also even within the discussion, I think within the European Parliament and within the European Court, you see that retention as a method, we have discussion about how long and why and how much, but as a method is a method that law enforcement is expected to use. So I don't see, well, that there's a big difference between those. It also depends on what kind of cases that you are investing.
Thank you. Mr. Pestman?
Yeah, very briefly. I was looking at that picture, and it's a worrying thought for a criminal defense lawyer to know that before and after the lock, it is always possible to monitor conversations. Before the internet, the World Wide Web was invented, I used to advise my clients to go for a walk and have a conversation. And sometimes in American films you see that they go for a walk and then cover their mouths. I don't think that is necessary. But that is, as far as I understand, still the best advice to give to my clients. If they don't want their conversations or the conversations they have with me to be tapped or monitored, it's not sufficient to use encryption. You should not use the internet. The question is, I don't want to be repetitive. The question is not what is technically possible or not. As far as I know, technically a lot is possible. You can hack the phone, you can tap a room where a computer is placed or where conversations take place. The question is, who determines whether you are allowed to tap or hack the phone or put a tap or a microphone in the room? That's the question that should be answered, and it should not be the government.
Just as was said, that we have to make a distinction between mass surveillance and criminal investigation. Also, I think I would like, to discuss with you. I think if you say to your client, you should, protect your mouth or go outside. I can understand this from your position, from having the privacy between a lawyer and somebody who is a suspect. I don't think you intend to say to a possible criminal, well, protect everything so you can commit your crime. That's a difference. And I think the task of law enforcement is to protect or investigate crimes that have been committed. Then they should be protected by lawyers. But it's not, the argument that you use to protect your conversation is not the argument that should be used in law investigations, law enforcement investigations. It's something completely different, as intelligence and law enforcement is something completely different.
Well, we are talking to somebody from an office who was being wiretapped by the government, so it is relevant.
Can I briefly add to something?
Yeah.
Because I agree, it shouldn't be the government who decides who can be wiretapped or hacked. That should be a judge, and that's also the proposal in the Netherlands at the moment. But we aren't allowed to do that at the moment, so we won't do it. And with that, a lot of crimes are being committed that we can't solve. And what I'm pleading about is give law enforcement agencies more possibilities under strict conditions to solve crimes.
But I'm going to ask you one question before we open the second round, because this is, of course, and somebody in the audience, I think, said it also. If indeed law enforcement is and even intelligence is hampered so much by things like encryption, then we would need to know, how much that is, and what the solution to that is. If the only solution to that would be to reduce the rights and the right to privacy of all innocent people, or if there are possibly other solutions. But first we would need to know the extent of the problem. And that I find and we're not talking specifically about encryption, but in many different areas that I've been dealing with in the course of the years, that we are always told, we need more powers because we are handicapped, we cannot solve crimes, or we cannot provide security. And then you ask, okay, well, give us some facts and figures, and then it remains silent. Case for data retention, for example, I have yet to see a convincing report outlining, the real need for data retention, and that would be very helpful, because if lawmakers like myself are being asked to pass legislation to extend the powers of law enforcement authorities, then we would need a reason to do so, and that reason cannot be, just trust us, we're the government, to paraphrase. But there has to be more evidence on the table, just as you need evidence to get a criminal convicted. We need evidence in order to restrict the rights of citizens, because that's what we're actually talking about. Okay, a second round and last round of questions. Okay, there are more questions than we can take. You were first, then there was the gentleman over there. Okay, I'm going to take one of the two ladies and the gentleman in the back, and that's it. You're first, yes.
Thanks, Sophie. So I'll try and keep this really short. I think that your last comment actually cut to the core of it here, and it was about accountability. I think if we learned anything from Snowden's revelations, it was that the protections that we thought we had systemically through the law were being disregarded. And so principles of necessity and proportionality had been disregarded. So I think that question of safeguards is the key one. As you said, if we're going to infringe on the rights of everyone, what safeguards can be put in place to ensure that that's not done inappropriately and that those powers are not abused? Regrettably, as you'll have picked up from my accent, I'm from the UK, and there I'm ashamed to say my government's response on that seems to be to change the law to legalise what they had been doing without proper legal cover before.
That's not the monopoly of the UK, I'm afraid.
Well, I was going to ask, can the panel give us any reassurance that that picture is not as widespread as I fear?
No. Okay. Before I go to the next one, I think there's a key element in the point that was just made, because sometimes you hear law enforcement people complain that their hands are tied to their backs and they're handicapped in exercising their tasks. But I think one of the reasons that that's happening is because powers have been abused and people are losing their trust in government. They're losing their trust. Precisely what you said. We thought we could rely on legal protection. And now we know that that's not the case. So, well, maybe we should have known before as well. But but that's something that we need to keep in mind. Okay, the gentleman over there.
Yeah. Actually, it was a question for the lady that left, but I will still ask a question. So I think she was suggesting to use metadata, basically to track criminals. And I was wondering, since the metadata is so powerful, why is it more acceptable, actually, in terms of privacy, to use metadata than actual data?
I thought we weren't so keen on using metadata
either. No, I was surprised.
So that was then, this is now. Okay, but Mr. Van Gemert can answer to this afterwards. One of the two ladies, I don't know if you've decided. Yeah.
She was just holding up her hand because she's taller. So this issue of not knowing why law enforcement agencies need to decrypt is somewhat answered in the reports of the Interception of Communications Commissioner in the UK, because the UK can compel decryption and actually surrender of encryption keys. And if you look at these reports, a predominant concern is actually child pornography. And so you can actually see the breakdown of when they've ordered decrypts. So if that's the problem, that is a serious problem. It's not terrorism, but it's a serious problem made considerably worse by the internet. The concern that I have is that a number of countries, including several in Europe, consider homosexuality a criminal offense. And so there are certain countries, chief among them Russia, where when I hear the phrase protection of minors or exploitation of minors, I kind of know this is code for let's suppress the gay people. So, just some thoughts from you guys, how much of this decryption activity is connected to child pornography, and then how do you protect a particularly vulnerable population where, teenagers in particular have a particular need to reach out to one another? Thank you.
Okay, thank you. And the last question, gentleman in the back.
Thanks. My name is Jaap Koopman from the Privacy and Identity Lab in the Netherlands. I just had a sort of a comment. I'm very pleased to see even law enforcement saying that they're all in favor of strong encryption, but they sort of see as their way out the endpoints. And I'm sort of afraid that we will having a debate or a discussion about the right on secure devices in a couple of years, because that's the next step then. And so the real question is how to deal with that. I mean, if the devices, if the endpoints are really secure, and you see a movement like device encryption towards that, what's the response of law enforcement in that case?
Okay, now before coming back to the panel, I'm going to put the question to the audience, because you're all much more knowledgeable than I am in IT matters. I'm actually in IT 0. But is there anybody in the room who feels that this issue, because we're now talking about basically all or nothing at all, with very few in-between solutions, and for the time being, it seems that we would have to rely on legal protection. But is there anybody in the room who says, "Oh, but this whole debate is outdated, because within a few years we will have technical solutions to this, and it will be possible to, on the one hand, have encryption for people who want to protect themselves, who want to protect their own privacy, protect themselves against criminals, and on the other hand, give law enforcement the tools they need to do their job." So, who would predict that in a few years' time there would be a technical solution? Here's the optimist.
No, Moritz Bartel. I'm a core member of the anonymization project Tor. I'm a technologist. the danger that I see, if you're talking about hacking and the whole point about secure devices in the future, is a very important one, because if you incentivize the government to know about vulnerabilities of systems and not work with the companies to get them fixed, it is vulnerabilities in the system that you preserve for yourself, but at the same time you leave them open knowingly for others to potentially find the same weakness in the system. So either you work with the companies to get this is the backdoor discussion, right? About like a legal access to systems, but then it's a question of who has the authority to access that data. We had the example of Russia, but we can find enough other countries and examples where we wouldn't want the government to have that kind of access to the data. So it's a question of how do we design systems and then have some authority that everyone agrees on should have access. And I doubt, as a technologist, it's not a technology question. That is, the question is, yes, potentially you can build systems that have these access methods, but it's a society question of whether we can allow any authority to have that much power over any device.
Well, that's the core question. It's not about yes or no encryption. It's about, we should, and it's not even about the question, should authorities have the right to access communications or devices or whatever we are talking about in order to solve crimes, but only that. And are we willing to, because the price for that would be that they potentially get access to everything. That's, of course, the big dilemma. Okay, we're coming to our concluding remarks. Mr. Pestman?
No, I have no concluding remarks.
Okay, that's a very quick conclusion. Mr. van Gemert?
I just want to respond, if you allow me, to a few of the things that have been said. About trust, I think I agree. Trust is the most important thing also for law enforcement. But it's also something, it has to do with transparency, getting into discussion with the citizens, but also making sure that this trust is it's not only about trust about protecting privacy, it's also trust in law enforcement in finding criminals, in protecting the rights of the victims, more or less. So it's a balanced, I think, once again, well, as everything in life, it should be a balanced way of looking into this. So as it goes for the question about, I also deliberately didn't mention the child pornography, but we really have a problem in this field. One dark web investigation in which there were different fora made clear that out of those fora, only 5% were related to child pornography. But they were responsible for more than 80% of all the data that was going on. So yes, it's being used in that way, and we really have to do something about this in this field. And I don't want to play this card every time, but it's also a realistic situation in which we have to come to a solution.
But you found these people.
Now we found, what we saw at that moment was that they were a member of a community, that they were only 5% of the total, and that they were using 80% of the data. Okay, so we are not able at that moment to, we found some of them, and also, thank you for acknowledging that Silk Road was a solution also, but it was also part of the fact that we combined methods that are not being used in every country. And just to end, I think, on the working together, I agree, we should work together between law enforcement and privacy. And I think the question about do we share this information with everybody, that's also actual at this moment. We don't share everything. Europol is not allowed to work with every state within the world. So that we put limits towards this, and there should be a control. It could be the parliament, it could be a judge who is responsible. That's the way we are dealing within our society and should stay also like this. Thank you.
Thank you. Mr. Egberts?
Yeah. Well, you asked me for examples of the threat. I would be delighted to provide them to you. So, because that's what we really want to do as a public prosecutor's office, explain why we think we need the extra authority. To Tor or to getting the keys, the decryption keys, some methods use keys and you can ask the company to decrypt the data. but that immediately sets up companies who say, we don't have the keys to decrypt the data. And most of the users will choose for those companies because then you're safe. And I can understand. So it isn't an option to think that we as a government can oblige a company to build in backdoors or to give us the decryption keys, because the companies are everywhere. Most of the companies we can't even, we can only email them and they won't respond. So that isn't a real option. We have to look at other options and not the option where you build in a backdoor and you oblige a company to provide data. That won't work.
As we have done for many decades with telephone systems, of course,
Yeah.
where telephone providers or companies were obliged to build in backdoors.
To build in the possibility
allow for,
and the technological measures companies can take at the moment, or all the developments make it impossible to oblige all those companies to build in backdoors. The communication by telephone, which isn't through the internet anymore, becomes smaller and smaller. So everything is data. Within a few years, everything is data, and you can encrypt it through a company you don't know. You don't know where it's located, and you just have an app for 99 cents. Some of them work, some of them don't. Yeah.
Which ones?
Okay, I would like to thank the panelists very much, Mr. Pestman, Mr. van Gemert, Mr. Egberts. I have the feeling that, or I'm left with a slightly frustrated feeling, I have to say, because we didn't come to a conclusion or an answer to the problem. But I'm glad that we have it on the agenda, because I really think it's essential, because this is, on the one hand, people want to be safe from crime, obviously. On the other hand, we live in a democracy and we'd like to keep it that way, and that means that there are limits to what governments can do, and not only limited by law, but also technically. So I'm sure that we're going to have more debates on this, and again, I wouldn't be surprised if we get a proposal on the table for a European directive on encryption or backdoors or whatever. So I think this was the first contribution to the debate we're surely going to have. Thank you all very much. Thanks to everybody in the room, in the audience here present. Thank you for your questions and your attention, and I hope to see you at the next privacy panel. Thank you.